Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone. Keith Fuicelli here for another episode of the Colorado Trial Lawyer Connection podcast. And as I think you all know, we love to interview Colorado trial lawyers after they've gone to trial and achieved a result that is worth talking about. And this is 100% one of those situations. And I am thrilled to have Melanie Sulkin here from the Crivet Law Firm to talk about a fantastic result she received, and her and her team, of course, out in Jefferson County. So welcome to the show.
Thanks for having me, Keith.
Great. Well, one of the things that I like to do before we dig into the case is to get to know people a little bit better. So how is it that you became a trial lawyer? Tell us a little bit about yourself.
Sure. So when I was in undergrad, actually studying media studies, I wanted to be a film editor. I picked up a poli-sci minor and ended up, as part of my honors coursework, becoming part of the mock trial team and actually helping found its introductory season.
In undergrad, you were on the mock trial team?
I was, yeah.
Wow.
So American Mock Trial Association, we started the Northern Illinois University mock trial team, and I competed in our inaugural season. And so the case we were trying was actually a wrongful death case, and I couldn't see it from any other perspective other than the plaintiff side. And so I knew that I'd found my calling. I wanted to be a plaintiff attorney. And so I went to law school with that in mind. I don't necessarily think that's the typical path, but I went to law school. I knew I always wanted to be a plaintiff side attorney, and I wanted to be a trial attorney. And so I did what I needed to do to get here.
So I heard you say Illinois. So did you grow up in Illinois, or that's where you went to undergrad?
Yeah, I grew up in the northwest suburbs of Chicago. I went to undergraduate at Northern Illinois University.
Okay.
And I'm a big NIU football fan. They just joined the Mountain West Conference. And then I went to law school at Indiana University before moving out to Colorado right after I graduated.
And so what brought you out to Colorado?
I just needed a change after law school. Spending your entire life in the flat Midwest where the humidity makes winters unbearable made you really want for a more sunny winter and just better weather and work-life balance overall.
Work-life balance. Okay, so you come to Colorado, and how did you get into the plaintiff side legal field? Was it hard to find a job, or were you able to get your foot in the door? And I guess what I'm really asking is for younger listeners that, like you, think, you know what, I really want to get in the plaintiff's world. A, tell us about your journey, and B, do you have any advice for people on how to get their nose under the tent, so to speak?
Yeah, so I got a job on the plaintiff side immediately following law school. I was out here taking the bar exam, and I had scoured the internet, every single source, Indeed, LinkedIn, Glassdoor, and Craigslist too.
Okay.
And I found a smaller plaintiff side firm hiring for an associate position. I reached out, I explained who I was, why I wanted to be a plaintiff attorney. I got an interview. I started working there, I think, while I was waiting for my bar exam results.
Okay, and then how long? Because I know eventually you found yourself in the world of, I don't know, mass torts, but product liability, high-level medical device cases. So how did you come from a small plaintiff firm to doing product liability medical device cases?
Yeah, so I was at the first personal injury law firm for about 6 months. It was a trying experience, I'm not going to lie. I was handed 45 cases in litigation.
Whoa.
Right out of law school. I was given the Colorado Rules of Civil Procedure, had a little bit of a primer, and basically told to just go.
Okay. We won't name that firm.
We won't name that firm.
Okay, sounds good.
But after that, I applied for and received a pre-suit position at Backus and Schenker. And I worked my way up there. After I was there for about a year in pre-suit, one of the partners over there, Chris Elliott, who's still one of my good friends, to this day gave me a chance to come work with him in the mass tort department, where we were handling all sorts of MDL cases. If you're not familiar with what a multi-district litigation is, it is a injury type case that's consolidated for pretrial purposes only. So discovery, general causation workup, and it's centralized for those proceedings. There are test trials, and if the cases don't settle when they're centralized, they get sent back for remand, which means they get sent back to where they should have been filed originally.
Okay. So when these cases were sent back via remand, were you handling sort of one-off cases that were actively in litigation at that stage?
Yeah, so MDLs are in different stages, and cases are sent back in waves. So
Mm.
some of my cases were still consolidated in the MDL, and then other cases were sent back and remanded, and I handled those upon remand as well. And the way I got into trial work in the more complex product world is one of our remanded cases, myself and Chris Elliott were working up for trial. It was a metal on metal hip case against Biomet Orthopedics.
Okay.
And so we enlisted the help of Darren Shanker and Jessica Reynolds and Zachary Wold. The two of them, those last two, are out of Louisiana. And we ended up trying the very first M2a Magnum Biomet case that was ever tried in the country.
And the location of that was
The
the
Eastern
trial?
District of Missouri.
Okay. And the result, which I think I know the answer, but what was the result of that case?
We got a $21 million verdict. $21 million for the injured plaintiff and $1 million for the consortium plaintiff.
All right. So I'm very curious. Tell us a little bit about the difference in working on product liability medical device cases versus, say, a car crash case in terms of, obviously, it's much more complex. But what did you like and what did you not like about doing high level product liability cases?
So the things I liked were generally the defendant. Usually when you're suing a medical device manufacturer, something's gone pretty wrong, and there's a lot of very compelling internal documents. And you see some things that make you pause and go, I can't believe people think that way. I can't believe people disregard safety of others in that way when they're supposed to be a medical device manufacturer. I kind of call it Jekyll and Hyde. I do think that medical device manufacturers and pharmaceutical companies do a lot of good, but at the same time, they have this facet of them that's so profit motivated that they know at the end of the day, even when they get sued, they'll still have made way more money selling this product than paying out in claims. And so I like that there's bad conduct you're punishing, whereas in most car crashes, you're dealing with more of negligence. Somebody did make a mistake, it's an individual, and you do have a little bit more sympathy for them because they're probably not super sophisticated like a company is. And so I like that aspect. In addition to, I think it's somewhat of a higher level of briefing, of legal research, of those nerdier things that I really like to do.
Okay. And so when you get one of these one off cases, if you're, I'm hearing you that your firm was actively involved in the MDLs. And so when you get these one off cases, are you provided with all of the documents you need? I mean, you're not conducting discovery on these cases, are you?
So yes and no.
Okay.
So generally when it's in the MDL stage, there is general discovery being done. That's done, our firm was participating in the general discovery as well, and that's generally against the defendant. That sort of discovery takes millions of dollars because you're dealing with millions of documents, you're dealing with sort of AI e-discovery software, and I'm sure people have seen job listings for, discovery reviewer or doc reviewer, and it's basically just going through and tagging things as hot documents or important documents, or this one supports the claim, this one has nothing important, and then AI sort of guesses what other documents might be relevant. But when the cases get remanded, or alternatively, if the judge doesn't allow, for example, punitive damages discovery and leaves that to state courts because not all states allow for punitive damages or financial discovery. For example, in Colorado, you can't really introduce the financial condition of the defendant to prove punitive damages, but in other states you certainly can.
Okay.
And
Yep.
so On remand, you do get to do that discovery that's specific to your case and also potentially punitive damages discovery.
Got it. So it sounds, in my mind, I'm thinking the upside of doing that kind of work is it's intellectually stimulating and rewarding, challenging. I've heard, I've not done that kind of work in a deep dive, but you're dealing with very good lawyers on both sides, experts that are top tier. And I guess what's the downside other than you can work on one case at a time? At least in my mind, I'm working on one case at a time if that's the kind of work that I'm doing. What's the downside to that world?
So you're generally not working on one case at a time. It's one of many cases. And I would say the time commitment to one case probably equals, 5 car crash cases. And
Okay.
so the time commitment's huge. Usually the other side has, 15 attorneys telling you you're missing one document and following up with you every single day and listing out a parade of horribles. I mean, it's discovery disputes on steroids.
Right.
It's a game to them. How can I make this plaintiff attorney say uncle? And so you always have to sort of be one step ahead to make it so most of these cases are in federal court to where the federal judges aren't sanctioning you or saying you're in contempt of court or something like that, because it's so easy if you have a boilerplate objection for the defense attorney to just exploit that and make it look like you're a terrible attorney and a terrible person and you're just delaying the case from moving forward.
Wow. All right. So you're involved in this trial team, you get this amazing result, and then at some point you branch out and go work with David. Is that right?
Yeah, so I was at Backus and Schenker for about 7 years, and 6 of those I was doing mass tort and
Okay.
catastrophic single event cases. I not only did products liability, I also was part of the trial team that did a medical malpractice case. We worked up car crash cases, anything that sort of had a catastrophic component involved. I was always the youngest member of the trial team, least experienced, and so I did get a lot of opportunities to do a lot of cool briefing, oral arguments. I did get to take some witnesses in trial, but ultimately, I was third, fourth, fifth chairing trials, and I really wanted to have a little bit more autonomy. I wanted to be able to first and second chair trials, and I wanted just a little bit more control over my work-life balance and schedule. And so I had met Dave when he was a partner at Backus and Schenker. He had branched off on his own and he had grown the firm to the point where he needed some help. He posted that he needed some help on briefing or something like that. And I reached out to him and I said, I'm looking to sort of branch out on my own. And he said, well, I need more help than just briefing. Let's team up.
Great. Okay. And so how long ago was it that you teamed up with him?
The initial conversation happened December of 2023, and then I made the leap in just about a year ago, January of 2024.
All right. And then part of that leap, we're here to talk about this trial that you did that you were certainly very, very involved with. Why don't you tell us a little bit about the facts of this case? And I'd like to start with the result, just so people aren't sort of sitting by wondering what the end result was. So tell us a little bit about the facts, the result, and then we can dig in.
Yeah, so the result was it was about $582,000, well, close to $583,000 for the verdict. And that was with $117,000 in past meds, no future medicals. And so the majority of the verdict was split between non-economic damages and physical impairment.
And one of the things that is fascinating about this case that all of our listeners need to know is there was little to no property damage on both cars, essentially. Did I get that right?
Yeah, at least visible property damage. So my client had a trailer hitch on the back of her car.
Okay.
And the trailer hitch had gone through the bumper of the vehicle that rear-ended her. Both of them, my client was driving a Toyota 4Runner. The defendant was driving a Nissan Xterra. So both bigger vehicles. The only damage that you could see on the defendant's vehicle was the hole from the trailer hitch.
Okay.
He had testified that it didn't even get repaired. That's how little he cared about the damage. And then to our client's car, you could barely see anything because it hit the trailer hitch. Now, she did have about $5,000 in property damage to the frame,
Wow.
And that's importantly later between the frame and the bumper, things like that. But the trailer hitch, I think, covered up a lot of the property damage, and there weren't great pictures of the damage done to the car.
All right. So I want to dive in deeper on this trailer hitch issue. But before we do that, what was your venue?
Jefferson County.
Okay. So relatively conservative venue, and your judge?
Judge Malud.
Okay. And I'm not familiar with Judge Malud. Anything you can tell our listeners about how is Judge Malud a man or a woman?
A woman.
Okay. I should know that.
Her first name is Megan.
Okay.
Megan or Megan.
Okay. And anything that we should know about how she runs her courtroom?
I think she really lets you try your case, for the most part. There were some issues, so we filed several motions in limine that were very specific to the case. And my approach in motions in limine is write out all the things you don't want in and only file motions in limine on that. Don't file boilerplate MILs. I feel that judges think it's a waste of time. So I want to get to the meat of it. And so she did grant very crucial motions in limine.
Which were what?
So collateral source, that one was an easy one for her to grant. But I think the most crucial was any evidence related to a fault of another person.
Okay.
The defendant late in the game admitted liability, and so fault should not have been an issue. So I moved to exclude any suggestions or references of my client slamming on her brakes or changing lanes in front of the defendant, or stopping abruptly, or the defendant skidding on something, because it just didn't matter. The only issues in the case are causation of injuries and damage, and how much she's damaged. So that was crucial to the case.
And was that contested? And I guess if it was contested, what evidence was there that they were trying to shoehorn in?
Yeah, so it was contested. Opposing counsel actually opposed every single one of my motions in limine, and including collateral source, which is odd. The defendant had an ever-changing story. So at the scene, he said he rear-ended her, and then a little bit later on, his mother showed up to the scene, and the mom tried to pressure my client to actually leave the scene before the police showed up.
Wow.
Yes. Then he switched his story to she stopped abruptly and slammed on her brakes. And then during the case, when I was deposing him, he said that my client changed lanes in front of him and then stopped abruptly. So there were all sorts of things that I thought the defendant would say to try and make it seem like he wasn't negligent, even though he had already admitted he was at fault and that he was negligent.
Okay. And did they allege comparative negligence, and then did they withdraw that, or was it just never alleged?
So they did allege it initially in the answer, but prior to the summary judgment deadline, I conferred on comparative negligence, whether it would be withdrawn, and the elements of duty and breach, and opposing counsel agreed to not dispute those two elements and to withdraw the comparative negligence.
Okay. And so I'm optimistic that based on those facts, that comparative negligence is withdrawn, admission of liability, the judge grants your motion, and none of those different stories come in, as much as maybe they would have helped you because the ever-changing story of the defendant, et cetera, et cetera. But did the judge grant your motion?
Yes, the judge did grant my motion. During trial, opposing counsel did try and elicit some of that, but I stood up, objected, and the objection was sustained.
Okay, fabulous. So let's dive in a little bit about this trailer hitch issue. My first question is, I think most of our listeners are probably familiar with the study that talks about 30-something% increase in injuries with trailer hitches, et cetera. Did you utilize that study, or how did you go about explaining to the jurors in simple terms why the trailer hitch mattered?
So we sort of tried we didn't think it would be an issue in this particular case, on the increased risk of injury. We figured it might come up with mechanism of injury since it was a rotator cuff tear case, with a rear end, which some physicians think a rear end crash can't cause a rotator cuff tear. We obviously disagree with that, and all of the doctors in our client's case disagreed with that. Instead, we focused on, we looked at the property damage estimate. And while the property damage didn't look like a lot, we noticed that the frame was repaired. And we had our client testify about the types of repairs that were done on her vehicle. And we said, oh, wow, this crash was hard enough to cause, it was metal on metal, and it was hard enough to cause frame damage in your very large new car. That's significant. And so I don't think that they had any question on mechanism of injury or that the crash could have caused this type of injury, even with the low visible property damage. We dealt with that in opening statements. We showed photos of the car and said, you might not be able to see a lot on this photograph, but you're going to hear that there was frame damage.
Yeah, I love what you all did there because it's sort of the whole Keith Mitnick ideal situation where you look at the damage at the repair estimates and there's frame damage. And so it seems like every time I have one of these cases where there's not a lot of visible property damage, there's no mention of frame repair or any kind of damage. So I have not been so lucky. Now, did you get the repair estimate in through your client just testifying about the repairs that were done on her car?
I think so. And sitting here, I can't recall whether or not we actually admitted it into evidence or just asked about her personal knowledge of what was repaired.
Okay, love that. Now, how did you address, what were your main concerns? It sounds like we've kind of covered most of them, but what were your main concerns going into the trial? And then how did you address them in voir dire? What was sort of these are the things I'm really concerned about, and I'm going to bring them up in voir dire, and here's how we did it.
Yeah, I think the main things we were concerned with were the non-economic damages and the physical impairment damages. I mean, our client, she was 43 at the time of crash, very active, in great health. And she recovered pretty well from her rotator cuff repair surgery. I mean, looking at her sitting there, and I think one of the jurors commented on this when I was asking them questions in voir dire, she looks fine. That's what one of the jurors said. She looks fine. I wouldn't award her anything more than medicals, if that.
This is like every Keith Mitnick issue in one little case here. So what a great response from your potential juror. Love that.
Yeah. And so we were able to strike a lot of jurors. So I used burden of proof and whether or not they were okay with a preponderance of the evidence in proving non-economic damages or if they would need more. So I combined those two topics because I think money for pain and money for impairment is some of the most difficult areas that people have with plaintiff side personal injury or personal injury cases in general. And so I wanted to make sure that I made every single one of those jurors who didn't believe in money for pain or who wanted to see, so much evidence. I need more than that. I need more than 51%. I wanted all of them to tell me it was an uphill battle. I would have an uphill battle proving my case. And so that was my tactic in voir dire, and I did that in this trial, and I did it in a case in June, and I was successful in getting, I think, 7 jurors struck for cause because they couldn't follow the standard. They said they'd need more evidence than that in order to award damages.
Wow. So, and originally I thought this was a first party case against, a underinsured motorist carrier or something, but this was a third party claim. And how did you deal with sort of trying to negate the bias that, this poor defendant's going to have to pay this money out of pocket? Did you try to address that in voir dire in any way?
A little bit. I think I said, you're not allowed to take into consideration, his age or that he's able to pay and, who's uncomfortable with that. But I didn't focus on it too much because I knew that there would be instructions on it, and I knew Dave would cover that in opening or closing.
Okay, great. So you hit these issues of the burden of proof and as it applies to non-economic damages. And so was the thought there in voir dire, I want to start introducing the jurors to this concept of impairment and non-economic damages being two separate categories to sort of start that conversation?
I didn't even, treat it as separate. I sort of lumped them together. I knew it would get explained. I knew Dave in opening would explain the differences in damages. I thought a good way of striking jurors would be talking about pain and suffering and sort of explaining what that is. It really got some jurors to talk about how unless a person had seen a therapist, they wouldn't believe that somebody was suffering. And so I think that assisted in helping to strike a lot of jurors for cause. And then for my peremptory challenges, it tuned me into who I needed to get off the jury. I knew in my mind that my client's damages, for the most part, had nothing to do with being sad or depressed or anything like that. But the fact that these people were so unwilling to consider that as a damage unless there was a substantial amount of therapy and unless they heard from a therapist made me worried about leaving them on.
So, did you end up with a jury that you liked? Because I feel like I've tried a lot of cases in Jefferson County, and the veneer is sort of all over the place. Were you happy with what you ended up with?
Yeah, I think there were maybe one or two jurors I was a little bit skeptical about, but after we picked the jury, we were certain who the foreperson would be, and we were right.
Sort of shifting gears a little bit, you talked about how you had a rotator cuff tear. Did you get into mechanism of injury in terms of where her hands were on the steering wheel and trying to explain to the jury how one can tear their rotator cuff in a rear end collision?
Yeah, so initially we didn't. And the reason behind that is because the defendant actually hired a Rule 35 examiner that admitted all of the care was reasonable and necessary and that it was all related to the crash, even if she might have had a pre-existing tear. And
Wow.
he sort of waffled on, I took his deposition and he sort of wanted to jam in, if we would have let him, he would have jammed in that he thought she had a pre-existing tear that became a full tear and then became symptomatic.
Okay.
Yeah. So originally we didn't focus on that. We just said everyone agrees that the need for surgery is caused by the crash. And the jurors had almost no questions until our last orthopedic surgeon testified. For the defense doctor, the jury submitted a question and they said, what is the mechanism of injury? And
Wow.
luckily in his deposition, when I had asked him that question, is there enough force to cause this type of injury? He said, I'm not a biomechanical engineer. I can't answer that. And so I objected to that question and it wasn't allowed to be asked. And then the next surgeon that was coming on, he wasn't super friendly. He doesn't do any medical legal work. He is just strictly a treating doctor. He was not going to go out on a limb and tell the jury that the tear itself was caused by the crash, but he would say that the symptoms were caused by the crash. The need for surgery was caused by the crash. But we just, about 10 minutes before he was set to testify via Zoom, I called him and I said, hey, what would be the mechanism of injury for a rotator cuff tear for rear end? And he said, if you have your hands on the steering wheel
Okay.
and force is applied to it, that's your mechanism. And I said, would you be willing to testify to that? He said, yes. Earlier in the case, we did set up that our client was seat belted and that her hands were on the steering wheel. So we did have that portion already set up. And we were hoping the jury would sort of infer that. But we wanted to make it crystal clear to them through our last treating surgeon that the mechanism of injury is in fact there.
Okay, so you were able to elicit that opinion testimony sort of at the very end, just in case there were any questions
Yep.
from the jurors?
Yes.
What I really like about your strategy is I was listening to another podcast and they were talking about how be careful what you set out to prove and that trials are about what we talk about. And so, my instinct would have been, well, gee, let's talk about how the trailer hitch increases injury and like trying to all this effort to defeat defense points. But it sounds like what you all did is sort of like, look, this is a given. No one's going to dispute. Even the doctor hired by the defense says
Yeah.
that this was related and we're really here to appraise the value of the damages here, and that's where the disagreement lies. So A, did I get that right? And B, was that sort of a strategic decision on your parts to frame it that way?
It was. It was strategic. We had the articles in our back pocket just in case the defense expert went rogue. We adversely directed him. And
Okay.
so we were able to control what he talked about from his report because we were the ones that called him. And Dave directed him and asked him very narrow and very specific leading questions. We had the articles just in case during his cross-examination he went rogue, but it ended up being okay and we didn't need to use them.
So what was the issue in dispute? Sounds like defense doctor agrees with everything. Was it just level of impairment? Did you go in with an impairment percentage or anything like that?
We didn't go in with an impairment percentage. The dispute was the valuation of the case. It was just
Okay.
non-economic damages and physical impairment. In our minds, this was a pretty traumatic surgery. It requires a lot of time to recover from it. And our client missed out on a lot of activities. I mean, she was a very, very expert rock climber. Took her out of rock climbing for, the better part of 2 years. She's not back to where she is. And their doctor, it was Dr. Chen, gave us permanency. He said she was at MMI. So she was at maximum medical improvement with a 30-degree difference in internal rotation between her dominant arm, which was the one that had the rotator cuff tear, and her other arm.
Wow.
And so he didn't think it was a big deal. He said there's not very many things she can't do, or she can do it in an augmented way. So we nailed it in. Okay, so it's permanent. You're saying that she has a 30-degree range of difference in internal rotation. Yes. That's what we kept the question narrow. We didn't want to ask him what that meant because we knew exactly what he was going to say, that it's not that big of a deal. And then his report said there's nothing else she can do to improve it. And so we said, oh, okay. So there's no issues with mitigation of damages.
Right.
So we just took that and said, and there's nothing else she can do. It's going to be like this the rest of her life. So that's sort of how we took it.
Okay. One of the things that I'm most impressed with this is that you did this trial in 3 days. And was that sort of intentional to try to keep this as short as possible? And assuming that it was, talk to us a little bit about who you called as witnesses and what the plan was to get this done so quickly.
Yeah, so it actually started because about a week before trial, the judge let us know she had a conflict and potentially had to move the trial. And we did everything we could to keep it on track. We told her, hey, judge, we can cut witnesses if you rule on the fault motion in the way you want us to. For example, we were going to call the police officer that responded to the scene if the court was going to deny the motion in limine on fault. I said, we can withdraw him and tell him he doesn't have to show up if you let this go forward and rule favorably on our motion. So we knew it was, the week before Christmas. So we knew that the court wanted this done quickly. We knew that there was a potential she was going to move it if we couldn't get it done quickly. And so we made decisions on who to cut. We cut one of the fact witnesses that was going to testify on damages because we just felt it might be overkill and it could do more harm than good. And so we just had a very, very streamlined case. We asked the questions we needed to ask for everybody except the plaintiff and get out. I mean, I don't think any of the directs, even for, the treating orthos, were more than an hour.
So talk to us a little bit about the damage model ask in closing. First of all, how did you go about figuring out what that ask was going to look like? And then what was it? How did you present it to the jury?
Yeah, so our client testified and she was the first witness that went. And we don't oftentimes do that, but we figured we'd set the scene early. She's someone that's very educated. She has a PhD.
Whoa.
Yeah, she's very credible. You always worry that somebody's going to come off like they're better than the jurors or they think that they're better than the jurors. And we did have some concerns with that. But we wanted her to set the stage about how the crash sort of happened, not getting into a lot of details to open the door. We wanted to set the scene on what was going to come from the other witnesses, so it was easier to connect the dots.
Okay.
And she testified that she still wakes up with pain, and it takes about 2 to 3 hours every day for the pain to go away. And then she testified that she needs to do her home exercise plan at least 4 or 5 times a week to just maintain what she's currently at. And if she doesn't do those exercises, she can feel it. And it's a mix of strength exercises and stretches and things like that. And so she's a high earner. I think her testimony was her salary is about $145,000 a year. We calculated her hourly wage, right, would be about $70 per hour. And we said, give her, for futures, give her an hour every day of her time. she spends more than that thinking about this. She spends more than that feeling the impacts of this car crash, but give her an hour every day for the rest of her life.
Did you break that up between non-economic damages and impairment, or did you keep them lumped together?
We broke it out separately. So we tried to focus on physical impairment as the future and pain and suffering as the past. And so we said for non-economic damages is the past. And so
Sure.
we asked for double medical bills for past non-economic damages. And then for physical impairment, we sort of couched that as what her limitations are going forward.
So the $70 per hour per day, which is brilliant. I love that idea because it doesn't really sound like that much, but you extend it over time, it ends up to be a large amount. Was
Yes.
that $70 per day applied to impairment?
Yes.
Okay. Wow. And so your total ask here was about what?
It was about, I think, if I recall correctly, it was between 1.4 and 1.5 million.
Okay.
We knew the jury was not going to award that. I mean, thankfully she did recover very well, but what she did lose for herself was very real.
You know, just to kind of backtrack a little bit, one of the things that I'm hearing about your case is that you had almost an ideal plaintiff in the sense that very athletic, outdoorsy, rock climbing, highly educated. And in Jefferson County, that seems like an ideal plaintiff, unless there are concerns that she's too educated to, above them type of concerns. Did you have those concerns? And if you did, what did you do to try to address those?
We really had those concerns. I mean, she's the type of client who, if we told her something, she'd go out and research it on her own.
Okay.
And so there's a little bit of worry that, especially on cross, that she would try and show the defense attorney how much smarter she was, or that the jurors would be turned off by her salary. We had a school teacher on the jury, and my client's profession was basically consulting school districts on what their curriculum should be. And
Wow.
we were worried that that juror would think, oh my God, she's just somebody who sits in an ivory tower telling me what she thinks the students need. She's not actually in the classroom.
Yeah, making 3 times as much as the teacher or whatever.
Exactly. And so rock climbing is also not a poor person's sport. We were worried she was going to talk about all the trips she took rock climbing, showing how wealthy she is. We were worried that some of the jurors would think she tore her rotator cuff rock climbing.
Sure.
So we did have all of those concerns, and we just said, be even keeled. We worked with her quite a bit. She wanted to contribute more information. She felt, she was most helpful when she was talking a lot. So we had to do a lot of work on just having it back a little.
Yeah, talk to us a little bit about your trial prep sessions with your client, just so we can all kind of get an idea of how to better prepare our clients for testifying.
Yeah, I mean, I think at the root of it, people are going to be who they're going to be. And our client she's pretty sophisticated, but that's not necessarily good or bad, because she might not take our advice at its face. She'll challenge us on it. And that's challenging too. Sometimes if somebody's maybe less educated, they say, well, my attorney told me to do this, and so I'm going to follow those instructions to a T. When you have somebody who's more educated, they're going to push back a little bit more. And it could be frustrating sometimes when you're the person who does this kind of work day in and day out. And so I do think the approach, first and foremost, depends on who your plaintiff is and what you see the issues with that plaintiff being. And so with this particular client right up front, I discussed with her what my concerns were.
Okay.
I let her absorb it because it can be hard to hear negative things about yourself. But I think it's important for people to know that and think about it and internalize it so they can recognize, okay, these aren't just things that are negative about me, in my everyday life, but I'm going to have 6 to 7 people judging me harshly and watching me during trial. Something I learned, I think, in my first trial was, you're part of the zoo. Every move you make is going to be judged. The jurors don't have their cell phones. When you're sitting there in the courtroom, even when you're not testifying, if you're twiddling your thumbs, if you're rocking back and forth in your chair, people are going to notice that. So working with clients on not seeming like they're faking it or that they're disinterested, or making sure that your client's not on their phone in the courtroom because the jurors can't be on the phone in their courtroom, making sure the client is present at all times because the jury has to be present. And then in other things, it's just for other types of prep, it's just going over the types of questions you think will be most problematic for your client. I would practice the direct entirely with your client.
Okay.
At least once. Don't do it too many times. It sounds coached.
Yeah.
But
Yeah.
if there's a bad answer, or an answer that sounds not great, you want to tell them that. You don't want the first time you're finding out about that answer to be when you're in front of the jury.
So talk to us a little bit about what the defense did on cross when your client was on the stand, and kind of like what was their angle on the whole thing?
She sort of took a few different approaches. One was, well, you can still do all of these things, right? It's really not that big of a difference in your life. Oh my God, cry me a river. Everybody's been through something way worse than this. Oh, how sad. You can't wash your back without using a loofah on a stick. Why can't you do it with your other hand? Things like that. And then she tried to, so one of the things my client could not do any longer, or partially couldn't do, is certain yoga poses. She was a pretty experienced yogi.
Okay.
And so positions like the push-up position, so chaturanga, or some more advanced positions, she couldn't do any longer. And I guess in my client's deposition, she didn't mention that she couldn't do yoga anymore. And so opposing counsel tried to call my client a liar and why were you hiding the activity of yoga from me? But luckily, she had put yoga on her sheet that she filled out for the Rule 35 examination, and that Rule 35 examination was done before the depo. And so on redirect, I pulled it out and showed it to her, and we were able to cure at least that portion of it.
Wow, that's good for you to be able to do that on the fly, because I'd be worried that I might not realize that oh wait, there's this document out there, because I'm assuming it wasn't in the list of did they ask her in written discovery, hey, tell us all the injuries things you can't do or whatever. And so I'm sort of hearing you say that, did it appear that the defense maybe was too aggressive in how they approached your client, or do you think they did the best they could with the limited bad facts that they had?
Yeah, I mean, it was hard to tell exactly what the strategy was. I think in their minds, they just thought, we're going to show the jury that this is a complainer. And that was, I think, our biggest concern, was that she just complains about everything. She's a Karen. And so I think that's what the defense was trying to do, especially when pitched against, a young kid who still lives at home and isn't super educated. I think she wanted to paint it more as maybe a David versus Goliath, or a complainer versus somebody who is this young kid. She's trying to ruin this kid's life. That was my thought on her strategy.
And hearing you say it like that, I mean, honestly, that would terrify me. So you have this sort of overeducated client you're worried might turn off the jury with a potentially sympathetic defendant. How did you all address those concerns in closing?
So, I think we first used written discovery and then the defendant's deposition to sort of nix that argument about this, poor kid and his life is going to be ruined by this crash. So we knew he was living at home. From his written discovery, he had had a really big gap in work. He had gone to community college to study reptile handling, and hadn't worked in like a year and a half. He testified in his deposition he no longer had the car from the crash, but that he had purchased himself a 2023 Toyota Tacoma, which those are expensive cars. We knew his mother showed up at the scene, made a big stink about, how my client shouldn't have called the police and how she was blowing this out of proportion and how the police didn't need to be called, things like that. And so the defense attorney tried to elicit some sympathy for him, like, oh, he saved up all this money to buy a truck on his own. He's such a responsible kid. He's just getting started in life. That was sort of the theme I saw on her direct examination. When I went up there on cross, I just immediately went into, well, congratulations on the new car, 2023 Toyota Tacomas, those are expensive vehicles, aren't they? So I got into that, and then I talked about how, and you haven't even worked in a year? And so I think that it's
What did
sort of,
he say in response to that? So that you haven't even worked in a year?
well, I picked up some odd jobs here and there. And then I said, do you remember I spoke with you in your deposition about, your work history? And you told me you hadn't really worked in about a year and a half. And he said, yeah, I remember testifying to that. So,
Wow. I mean, what a great practice pointer to sort of ask those questions in a deposition. You might not think you're going to need that. And then lo and behold, it's a powerful piece of ammunition to diffuse this sympathy angle that can come up. That's amazing. Tell me more about the cross of the defendant. How did he come off?
I think he came off as like a kind of dopey young guy.
Okay.
And I think that's how the defense attorney wanted him to come off. He's not a bad person. Most
Sure.
of the time in these cases, you're not dealing with somebody who's an awful person. It's just somebody who didn't want to take accountability. And during cross, I think that's how he came across. He did not want to take accountability. I think the last question on direct was, and how did it feel sitting here all week listening to this? And he said, awful. And so I got up there and I said, dealing dealing with this for a week, right? And it hasn't been fun. Nope. Okay, well, my client's been dealing with this for 2 years. How do you think that makes her feel? And, luckily he was earnest enough to say, probably not good. Um, but I wasn't scared of what he would say. I think any way he would have answered that would have been good for us.
Wow. Talk to us a little bit about settlement offers. Were there statutory offers in the case? And tell us how that played out.
Yeah, so we went to a pretty early mediation. This judge had you had to submit a stipulated settlement plan 35 days after the case was at issue. So we mediated before experts, and
Okay.
the initial offer didn't include anything having to do with the shoulder because initially the defendant didn't think it was related at all. And so it was under six figures, the initial settlement offer. After experts, we received a statutory offer of $225,000, which $117,000 in medical bills. That's not an offer to scoff at. And maybe
Sure.
if we were in pre-suit or it was earlier in the case, maybe that's something, that would have been considered a little bit more. We then offered $330,000. That was rejected. And then about a month before trial, we received a statutory offer of settlement of $275,000. We had a long, hard conversation with our client, and we ultimately decided that it'd be better to take this case to trial.
Great. And so what kind of policy were you working with here?
It was a $500,000 policy. So we knew, we made a demand within the limits, and we knew that if we went to trial, we could get an excess verdict. Another caveat, though, is originally, so we had taken over this case from our co-counsel for litigation purposes. Initially, the insurance company was served instead of the defendant. And so about 3 weeks before trial, I sent a process server to the defendant's house and had him served so that we could exceed the policy.
Okay, what you did with your amazing verdict, and then eventually, who was the insurer here? I'm not sure if we covered that.
American Family.
And did they pay the full verdict?
They paid the verdict. We're negotiating costs and interest. I think that they'll end up paying they're going to be paying all of the interest and 97% of the costs.
Well, one of the things that I am just very, very impressed with is, like you said, that $75,000 stat offer, that is significant on 115 in meds with hardly any property damage in Jefferson County. I mean, a lot of lawyers would have beat their clients up to take that offer. Yeah. I guess to the extent you feel comfortable, tell us how the conversation went with your client to empower them to either make the decision to go to trial. Help us understand how you threaded that needle of, I want to take this case to trial. I think we can do better, but there's risk involved. I find those are some of the hardest conversations we have. Any advice you could give me?
Yeah, so luckily we had an earlier stat offer that was easier to turn down. $225,000, it's nothing to scoff at, but I don't think that's the full value of the case. And I'd had that conversation with our client about what would go in her pocket after, costs and subrogation was paid.
Okay.
She had a self-funded ERISA plan. And
Got it.
so I could guarantee you they're not going to take much of reduction. And she felt that throughout the case that she'd sort of been gaslit by the defendant and his mom and opposing counsel. I mean, in the claims note, the mom had called and accused her of fraud and all these crazy things. And so the initial statutory offer, I think she thought, I think we can do better. And I told her, we probably can, but there's always a risk. If we lose, if we don't beat this, you're going to have to pay their costs. And she said, at least that's something I can live with. If a jury is telling me that I'm not that injured, at least, they're an independent, sort of neutral party. The $275,000. So when we were negotiating with American Family, they had essentially told us, if you demand $300, we'll probably be able to pay it.
Wow.
So after negotiations, we told that to our client. That was, I think, sort of our client's bottom line anyways. So we made the demand, and guess what? They couldn't pay it. And so I had the conversation with my client again, and I said, they're not getting to our bottom line. That's what they told us they would do, and they're not doing it. What do you want to do here? We still have the same risks with the statutory offer. And I explained to her, there's a recent appeals decision that came out about different statutory offers, and you have to beat both of them. Forget what the case is called, but to beat the first statutory offer, we would have needed a verdict of about $199,000. And to beat the second one, we would have needed about $235,000 because you have to include the interest and the cost to date. She was upset that, again, there was some more gaslighting going on. They told us to make a demand. We did it, and they didn't make good on it. And so I think the decision for her was pretty easy. She is a person of high integrity, and she wanted the insurance company to know that she meant what she said.
God, I love that. I love that we have those clients sometimes where you can sense the case is about more than money. Yeah. And your client had the means to take a little bit of a risk and to feel personally offended by what the insurance company is doing to her. So kudos to you and your team for a truly amazing result. And I don't know if we covered it, but who was defense counsel? And I apologize if we're repeating ourselves.
No, it was Nina Hamignan.
Okay.
She's in-house at American Family.
In-house, which probably explains why they paid the verdict, and just an amazing result. Well, first of all, thank you for taking time out of your very busy schedule to speak with us. That is just an amazing result. I like Jefferson County, and the jurors can be tough, but they're fair, and I love how you all did this in 3 days. And I feel like I have learned a ton from the time that we've spent together. So thank you so much for coming on the show.
Thanks for having me. And I just want to say, I think doing it in 3 days, Dave Krivitz owed a lot of credit. He's the one who's always telling me, stop being so wordy. People don't have attention spans for 3-hour direct examinations. Let's keep it short. Let's keep it interesting. Let's keep it to what they need to know. And so I think I don't want to leave out how his overall strategy contributed to the verdict.
Yeah, it's great. It's the whole speed trial. And I heard and believe firmly the shorter the trial, the bigger the verdict. And we just try to overcomplicate things. And this is just a perfect example of that success coming in 3 days, get in, get out, especially with, it seems like the real issues in dispute were so narrow. We were just here talking about the value of non-economic damages. Okay, let's go do it. So congratulations again to you and your team. And thank you so much for taking the time to come on the show. And thank you everybody for listening. I have to say that I recently had somebody reach out, which was a first, to say that they listen to the podcast and they appreciate it and that they're getting something out of it. And that is our whole mission and vision of doing this. Number one, selfish reasons for me, because every time I talk to people, I learn something new. I feel like I become better, but it's also to help everybody else out there and empower them and think, this isn't that hard. So go out there and get it. So thank you all for listening. Thank you, Melanie, for appearing, and we'll see you all next time on the Colorado Trial Lawyer Connection. Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.